Very happy Wednesday, January 8th to you, and welcome to another year of our Elville webinar series. Our topic to start the year off is estate planning and elder law essentials, and where better to go to start with something than the basics and the essentials. So your presenter is our very own managing principal and lead attorney, Stephen Elville, and I'll be your moderator for today's presentation. I'm Jeff Stauffer, for those that don't know. A few housekeeping items to get started. We always encourage your general questions, so please note them in the questions panel on your screen. We'll pause periodically to address them. And your questions are encouraged. They always help the presentation a lot, so thanks in advance. And yesterday by email, you received the presentation slides Steve is going to be referencing by email. If you didn't receive them for some reason, they're also in the section marked handouts to download at this time. And we'll also be sending you a post-webinar feedback message. So please take just a couple minutes to offer us your thoughts about today's presentation. And we always read and value every comment that you have to share with us. Let's start a question for you. Have you achieved your planning goals, or have those goals shifted since you last looked at your planning? Now, I'm not one that believes in New Year's resolutions, but I do think you need to be resolute in your planning. So whatever it may be, getting started, updating your documents, an administration matter, or something else, Steve and his team are always here to help and be a resource and advise you for next steps and a path forward for you. So I want to offer Steve and the firm a brief introduction. We've got a lot to cover in limited time, and we'll jump right into the presentation. So I'm going to share my screen now. Elville & Associates, been here since 2010. So Steve, 15 years. That's hard to believe. Congratulations there. We have many different practice areas that we focus on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, including beneficiary representation for certain matters, business law, guardianship and litigation, and tax planning and asset protection strategies. We have 9 attorneys, 12 staff members, and 3 locations. And we're coming to you live from the Columbia Gateway Community location today. And our mission, it's always been the same. It's to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we focus on education a lot here at the firm, and we do it in many different ways. Just a few of them include through our planning processes and work with our clients. And we have different programs to suit all families and individuals here at the firm. We also offer, as you're on right now, educational webinars and in-person presentations in the communities that we serve each year. And also by way of our accredited client care program. We're one of only a couple firms in Maryland to have a client care program accredited by the Client Care Academy up in Boston. Always, every day, we work with the ideals of client education, collaboration, and compassion in mind with every client at the firm. And just a bit about Steve. His work as an attorney for many, many years has been centered in elder law, special needs planning, and estate planning. A member of many different national membership and professional organizations and peer groups, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, the National Network of Estate Planning Attorneys, Wealth Council, many others. Steve works to offer peace of mind to clients by creating solutions to the needs through counseling, client education, and the use of leading edge legal technical knowledge. Steve's a very seasoned speaker and presenter, presenting at many webinars, workshops for businesses and their employees, different conferences, and continuing education events each year. 2025, congratulations, Steve, named to the Maryland Super Lawyers list for a 10th time and a 9th consecutive year, so well deserved. We can't call Steve a super lawyer, but I think he's pretty super, and we all do here at the firm. But named to the Maryland Super Lawyers list for a 10th time. Steve also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded way back in 2014. I'm very fortunate to be a part of that. If you'd like to learn how we work to make a musical difference in the lives of children each day, please reach out to me directly. I'd be very happy to share our story with you. I'm looking in my office right now. I have about, I'm going to say about 30 instruments, 30 to 40 instruments to deliver to some schools that are in need. So I'm looking forward to getting that done in the next week or so. So Steve, I'm going to go ahead and turn it over to you. How are you doing this Wednesday morning, Steve?
Well, I'm doing great. I'm shocked that you don't believe in New Year's resolutions, though.
I don't. I just try to. I try to stay steady and resolute through the year, Steve. That's my operative word.
I thought, my goodness, I've got to lose weight, get back to the gym. All right, let me get my screen up here, Jeff, and my slideshow. And I appreciate your wonderful introduction.
Well, thank you.
And I should be all situated here in just a second. All right, well, thank you again, Jeff, and greetings to everyone. New Year's greetings. I wish everyone a happy new year and blessings in the new year. And, you know, we appreciate you spending your time here on Wednesday, January the 8th. My goodness, Jeff. And as you can tell, Jeff and I have been giving presentations like this for quite some time. And Jeff, thank you for everything you do. And I'm very blessed to be here with you this morning and to lead you through some basic education. You know, I was thinking this morning, there are probably three C's to this kind of thing. You know, if you educate yourself, and I'm going to ask you here in just a second, why are you here this morning, spending your time on this cold Wednesday morning? But there's probably three elements at least that come out of this, and I just will call it the three C's for today. And I was thinking confidence. You'll gain confidence by being educated about planning. For those of you who are not already so educated. You'll also have choices that you didn't know, and that's going to lead to confidence, of course. But all of this is going to lead you to be aware of the need to collaborate, to have your financial advisors and your CPAs and tax preparers and attorneys and life insurance professionals and any kind of aging life care manager or other person that might be involved in your life or on your planning team or on your care team, whatever your situation is. And I think that's going to lead to confidence. So that's why we believe in the educational element. The other thing that I want to throw out here in 2025 is as we continue to forge into the future, I, like many other estate planning attorneys, are getting ready to attend the Heckerling Estate Planning Conference in Orlando, Florida next week, where thousands of estate planners from across the United States will come. And the one thing I'm reminded of every year when I go to this conference, which is huge and it's very, very dynamic and it's very technical in some ways, but the fundamentals never change. No matter what new things are going to be introduced, the fundamentals of people, wealthy people, not so wealthy people, older people, younger people, all kinds of people need the fundamentals of estate planning for what happens if you are incapacitated, what happens at my death, how do I take care of my loved ones, how do I plan for my own health care decisions and help my loved ones plan for their health care decisions. So many things to get our minds around in the fundamentals. So that's why we're here today, and we're just going to forge ahead. Thank you for being with us. We're going to end on time, I promise. And Jeff will take your questions. He will stop me if there are questions. And as you can see from this slide, we are not here to provide legal advice today. This is not legal advice, but there can be an attorney-client relationship, an attorney-client privilege attached to any kind of meeting that we may have eventually. But this is just high-level educational material. This is not legal advice. Let's get into the discussion now. For those of you who have never seen this presentation, this is going to be hopefully a mind-expanding exercise. I want you to use the presentation as a tool. Jeff has sent it to you. You can print it. You can store it. It is yours. You're going to know about 90% more than the average person knows about estate planning and elder law at the end of this discussion today. But remember, we live in a constantly evolving world, and that's why we continue to educate here at Elville & Associates, and why we are one of the only firms in the state of Maryland that has a client care program that is designed to encourage you to update your program and educate your family members as well. Let's talk about what an estate plan is today and what is the process. And if I had to do this slide again, I would make the process word in all caps. What is process? And if you have a tablet, piece of paper, anything that you're making notes on, even the old-fashioned way, I would circle the word process. Estate plans can fail, and how can we avoid that? That is number 2 here. Wills versus trust. This is the age-old question. Should I have a will? Should I have a trust? What happens if I have no will? We're going to talk about that a little bit. We're going to talk about some basics of elder law. What is elder law? What's going on in the world of taxation at a very high level? Asset protection. Wow, these are huge concepts that could take 2-day workshops just to get our mind around one of them. We're going to attempt to give you a little bit of this today, and so you can have a scope of knowledge. And we're going to talk about maybe one of the most important things today, which is getting started. You know, it's hard to not only get our minds around this whole idea, it's hard to plan for ourselves. Some of us don't think about ourselves. We're thinking about our family members. We're thinking about our loved ones. We live our lives, working hard to provide for them. We don't think a lot about ourselves, but we want to think about ourselves. How can we take care of ourselves so that we can take care of them as well? And how do we get started with this process? So we're going to talk about all of that. So we're going to talk about why we're planning, why are we here today? Let's just start with that. I'm going to time this for 1 minute, 60 seconds, and we are going to, really stick to the time frame here this morning. So don't worry about that. Let's take 60 seconds and just time ourselves. I want you to think about, why are you here today? Why are you spending your time doing this morning? And what are your concerns? I'm going to go over some typical concerns here in just a second, but what are your concerns and why are you here today? Let's start that right now. Some of you are here because you're concerned about your minor children. Some of you are here because you have aging parents and you have concerns. Some of you are here because you did estate planning years ago and you know you need to update your estate plan and you have questions. Others of you have questions or concerns about children or grandchildren or taxes. So just take a moment here. We're about 30 seconds into this exercise. Let's get grounded into the notion of why you are here. So again, on this slide, you are seeing the word process pop up there, and you're going to see that that is a big deal, in my opinion, whether or not we have a process of planning. All right, we're done with our 1 minute, so thank you for exercising that approach. Let's go to the next slide. So I want you to be thinking about why you're here. Why? Because all planning is goal-driven, G-O-A-L. Sorry for my voice this morning, goal-driven. I want you to have a goal. I want you to have a plan, just like you would have a plan for anything else that you would do. And I want you to think about not just planning one time. I want you to be thinking about planning for the rest of your life. So for those of you who may or may not have struggled with that little exercise, most people plan because they want certainty. They want to put things in place. They want smooth administration after we pass away. We want things to facilitate smoothly, which is kind of a scary thought if it doesn't, right? We want to minimize costs. For many people, that's a goal. Some people want to protect spouses and children and grandchildren or nieces and nephews from the claims of creditors or divorcing spouses and things like that. So we have some wonderful laws today to be able to do those kinds of things. So we'll talk about that more later. Some people are focused again on taxes. They are focused on minimizing taxes, and who can blame anyone for that? Income taxes, generation skipping taxes, inheritance taxes, gift taxes, estate taxes, and on and on. We talk about all of these things. Some of you have a special purpose. That could be charitable planning. It could be planning for a grandchild. It could be a special needs loved one, a person with disability. So I want you to be thinking about your purpose and your plan, because that's going to drive you. Even those of you who don't really think about yourselves, you think about others. This is going to drive you in your path towards getting your planning in the right order. Now, why do some plans not work? Okay, some plans don't work. A lot of plans don't work. Why? because people don't update their planning, right? It would be like someone who doesn't file their tax returns every year and then wonders why they have a tax problem, okay? A lot of people don't update their estate planning, and we know the average person, some of you are the persons I'm talking about, the average person doesn't update their planning if they have planning at all. They don't update that planning for about 19 to 20 years at a time. So let's look at our past planning if we have that and say it's time for an update. Let's think about if we don't have planning, and remember that about 60%, 55 to 60% of people have no planning at all. So don't feel bad if you're in that category, but it is time to take action. Now, we could talk all day about this, but I'm just going to give you a basic premise. There's probably two types of planning. One is the traditional type, and that is the planning that you may have heard about, where you meet with a lawyer or you go on the internet and you get a will or you get a basic document, and there's no education, there's no follow-up, it's just basically a transaction. Now, let me offer that if you want your planning to work over the long term for the rest of your life and at your death when it really matters, because we don't really know where we're going to be. I don't know where I'm going to be when I die. I don't know where you're going to be, and Jeff doesn't know where he's going to be when this time comes, God forbid. So when we think in terms of that, and we think in terms that traditional estate planning is just a transaction, we can start to imagine that when we consider our financial assets and how they flow in the estate plan, our retirement assets, life insurance assets, non-retirement assets, all of the things that are choices today with our financial advisor community, such as transferable on death designations and other things we're going to talk about today, we can see that there's a lot of factors that could affect how your estate plan actually flows down. So this is where the rubber meets the road, and this is where many people can have an estate plan that doesn't really work the way they thought it would. So we don't want this number one traditional estate planning approach. What we want is some kind, here's that word again, some kind of process-driven estate plan. So you have this material. I'm not going to hammer this anymore. This traditional process doesn't have education. It's just a transaction. This might be okay if we were in a very big emergency or we were traveling to the other side of the world. But overall, this traditional kind of estate planning is not going to work over the long term. What we want is some kind of process. It doesn't have to be a long process. It doesn't have to be an onerous process, but it does need to be some kind of organized process. I do another webinar that Jeff and I have done called Perfecting, or intentionally perfecting your estate plan. And in that, we get into more of the big deal with process. But here we have a very simple illustration. If you have a simple process, designing and implementing your plan through a process, and then updating and maintaining your plan throughout your lifetime, at our eventual deaths, at our final administration, it's going to be logical that our planning is going to work in a much better fashion than someone who never did any of that process-oriented plan. So in a process-driven plan, we believe here at Elville and Associates that there should be education. It could be video education. It doesn't have to be in-person education. It could be a Zoom meeting with your loved ones and your fiduciaries. It could be Zoom meetings with all of your advisors, making sure that everybody is collaborating together in your best interest. But see, in the absence of this process, we have what? We have no process, which in my opinion means chaos, especially in today's world. So we're living in a fast-paced world. We want to have a process, have an organized plan to update our estate planning over the years. Let's take one more minute and talk about estate planning definitions. So I want you to define for me, if for no other reason, to humor me this morning, give yourself 1 minute. What is estate planning to you? I'm going to give you 1 minute on this. 1 minute to define your definition of estate planning, and then I'm going to give you a very, very simple definition. But what is estate planning to you? We have about 45 seconds left. Remember, estate planning is very personal. Estate planning is arguably very emotional. Estate planning could be very, very, cryptic. It could be about taxes, but a lot of time estate planning is about love, and it's about providing for others and sharing your goals and values as we get down to about 5 seconds. All right, well, thank you again for engaging in that exercise, which I hope is helpful to you. Let me give you a very fundamental definition of estate planning. Estate planning is about disposing or leaving, however you want to say that, disposing or leaving of your property the way that you want to the persons or organizations, of your choice at the lowest possible cost. Now, this could be one definition. This person who defines it this way is saying, I don't want to spend a lot of money on the total package of my assets, disposing of them to my family members or charities. So estate planning is about disposing or leaving assets the way you want to the persons or organizations of your choice at the lowest possible cost. All right. So we've done the preliminaries. Now let's do the hard work. I'm going to get into this analysis of wills versus trusts. So all across America, this is one of the biggest issues. And what are we really talking about here? Well, we're talking about probate. We're talking about probate versus non-probate. So let's pretend that we have a will, and I'm just going to go to the next slide very briefly and go back to the next one, the previous one. So there's a will. And a typical will-based plan is a will, powers of attorney, advance directive. And what have we accomplished here? Well, the will is what happens at my death. The powers of attorney and advance directives, as we say here at Elville and Associates, is planning for life. What happens during my life, not just at my death. And for some people, this is an incredibly powerful, important concept because people are living a long time. So going back to the previous slide, if we have a will, there's a process. And that process at our death is a public process. That's called probate. Now, in some places like Virginia, and my Virginia colleagues tell me that probate is minimal compared to Maryland, compared to Delaware, compared to New York. But here in Maryland, we have robust probate. And what is probate? Probate is the proving of the will to be valid. Creditors are notified. There's an estate that has to be opened. There has to be an inventory unless it's a modified estate and so forth. There has to be an accounting. There has to be an administration. And then after everything is approved, that everyone's been notified, everybody has had fair notice, and all kinds of things that happen within the probate process, now the estate can be distributed. That is the probate process in a nutshell. Now, it can be streamlined in some cases it cannot. Now, those of you might say, well, Steve, what if there is no will? Well, if there is no will, there's still probate, because what if I had no will and I was single, okay? Whether I'm single or married, doesn't matter. I am single, I have a bank account, I have a brokerage account, and none of those assets have any beneficiary designations. And I also have a house. So if I died without a will, what would happen? Well, the laws of Maryland would take over. The intestacy laws would take over. So even in that circumstance, there has to be probate, even though there's no will. And my assets would go according to the intestacy laws of Maryland, which, according to the laws in the last couple of years, have changed. Some of our intestacy laws have been modified. So with a will, we have probate. If we have probate assets, so going back to the slide one more time, What is a probate asset? Well, a probate asset is an asset that I own with no joint owner, and no beneficiary. Okay, that is a probate asset, like that bank account that has just my name on it and no joint owner. Okay, that is a probate asset. Now, an IRA or a life insurance policy with a beneficiary is not a probate asset if that beneficiary survives me. Okay, so we have to get our minds around what is a probate asset and what is not. Now, conversely, one of the biggest issues in the United States is, should I have a revocable trust? And should I avoid probate through the use of a revocable trust? Now, many of you on this call have a revocable trust, or you're thinking about it, okay? What is a revocable trust? Well, a revocable trust is a substitute for a will. It is not rocket science. It is not complicated. It sounds complicated, but it really is just, well, I could have a will, or I can have a will substitute, okay? I can have a kind of a fancy will, so to speak, even though it's really not a will or a revocable trust. Now, wills, let's go back to that very quickly. Wills have a process, and wills have 2 steps. Whether people realize that or not is another story. The first one is to create the will and sign it. And the second step is to make sure beneficiary designations are correct. That's a second step, because without that second step, the will not work as planned, or the estate plan will not work as planned. Let's go to the revocable trust again. The revocable trust has 2 steps. If we want a revocable trust that will actually work, we have to go through these 2 steps. The first step is similar to the will. We have to create it. We have to be happy with it, design it, and sign it. So we implement the trust. That's the first step. The second step is to align our assets or fund our assets into the trust. Without this step, you have an estate plan that will not work. So your residence would typically go into the revocable trust, depending on your situation. Your non-retirement assets, cash, CDs, money markets, checking accounts, mutual funds, even savings bonds. These types of things would be inside the revocable trust. But life insurance, typical life insurance, or IRAs, 401ks, 457 plans, these qualified type plans and IRAs, they do not go in the revocable trust. Those are beneficiary designated. So we want to have a fully funded revocable trust if we want a trust that will work. So as a fundamental premise, we want to use a revocable trust if we want to avoid probate, if we want to have a superior incapacity planning tool, and there are other ancillary reasons to have a revocable trust. But look at this slide very carefully. If we use a revocable trust, is there creditor protection? The answer is no. The revocable trust does not protect assets from creditors or divorcing spouses or bankruptcy creditors. And there is no tax savings per se. There is no difference for estate tax, income tax, or other tax with regard to a will versus a revocable trust. So we want to use a revocable trust for what it is, which is a will substitute, and we want to know what it can do. It's a very nice management tool, but it does not do some of the things that people think it does. It is a probate avoidance device. So wills versus revocable trust. This is the fundamental question of estate planning. Jeff,
Steve,
I'm going to take a drink of water. Is there any question? Go ahead, Jeff.
You're reading my mind, Steve. Couple good questions here. And we'll start off with, what happens if a Maryland resident dies without a will?
Well, thank you for that. What happens is that that person will still have probate, and we would have to look at the intestacy laws of Maryland and say, based on this person's circumstances, are they married or single? Do they have children or not? That's going to dictate how their assets would flow. But the second analysis on that is, it depends on whether that person has probate assets. let's pretend that person has assets that are all beneficiary designated, or they have IRAs and that's all they have. Well, that person, even though they had no will, they will still not have any probate, even though they don't have a will. So it's going to depend on their assets. It's also going to, the result is going to depend on their family members. But in theory, they're going to have probate no matter what.
Okay, thank you. And one more related to our different practice areas. How are new clients assigned to specific associates at your firm? Just lost it here. There we go. For example, for a request to update a special needs trust, will I be assigned to a specialist in these trusts rather than, say, an elder law specialist?
Well, thank you for that wonderful question. Yeah, so we look at all appointment inquiries, and in consultation with you, for example, we would determine who you would best be suited to be scheduled with. If you have a special needs trust that's currently in place, for example, you have a trust that's already in place, that person or person like yourself should not be scheduled with an associate who is just a general estate planning associate. So you would be scheduled with someone who works with special needs trusts. Now, one thing I'll be clear about is that special needs, believe it or not, special needs planning is considered a part of elder law. So a person who is an elder law attorney at the firm, and we have at least 2 or 3 here, that person is assumingly, we're going to assume that that person is a person that would be qualified to meet with you about the special needs trust. But I would say in our firm, we have probably 2 people who are, that would include myself, me and another person. At least those 2 people are what we would call people who concentrate in special needs planning and would be more appropriate than others. But thank you for that really great question.
Okay, Steve, thanks very much.
All right, thank you everyone. And we're going to keep marching forward here. We're a little bit over the halfway point as far as our time. So remember, when we think about wills, we think about trusts, but here in the middle, we have another category, and this is the non-probate transfers that I mentioned a few times. Transfers on death, payable on death, like bank accounts, beneficiary designations, joint ownership, even life estate deeds. These are arrangements where it avoids probate. Now, the question when we use these tools, is it an oversimplification? So a good example, and I'm sure we have some financial advisor colleagues on this Zoom this morning, a good example would be a person works very hard to put their estate plan together. They have put a lot of their emotion and their time and effort into it. They are educating themselves. They've done all these things. But if a well-meaning financial advisor says, well, why don't we just make all of your brokerage accounts transferable on death? And what we're going to see in the next slide is you can have a great will or trust, and you can have done all of your due diligence. But this is why the second step, the beneficiary designations or the funding of the trust, if you have a trust, this is key, because that payable on death, or transferable on death, I should say, is going to go around the will or trust. So you could have articulated your goals very clearly, but yet your funding or the way that your assets are titled is going to possibly defeat your estate plan. So we want to make sure that your collaborative team is working together, that your estate planning attorneys and your financial advisors and CPAs are all on the same page, and that you as a potential client, for example, are not doing something that is going to unintentionally defeat your estate plan, like a transferable on death designation that would go outside of your estate planning and completely bypass it. So we just have to be very intentional about these things. We can use these devices, but we want to be sure that we understand why we're using them and what purpose is it that we're using them. The other argument is that this is not a good substitute for an estate plan, because this, for the vast majority of people, is going to be something that is too one-dimensional to really take advantage of all the good things that there are today in estate planning. So we don't normally think about these non-probate devices as estate plans in and of themselves. With this said, there are some exceptions. There are some very rare clients who do successfully used these non-probate transfers, but we do not recommend it because of the flexibility that would be lost if we have too one-dimensional of an estate plan. Now let's talk about incapacity, and I know this is a difficult subject. Hopefully you are healthy and well. Hopefully your loved ones are. Hopefully your older loved ones are. But this is one of the most important things. So let's look at this. When we look at an estate plan and we look at the ancillary documents, powers of attorney, advanced medical directives, what are we really doing? Well, we're planning for life, not just for death here at Elville & Associates, for example. But we're not just planning for life as a slogan. We are actually planning to avoid guardianship. We want to keep and maintain our right of self-determination. We want to make sure that we are controlling our own destiny. We don't want a circuit court. We don't want a guardian in control of us where we lose our legal rights. So arguably, not just for purposes of this webinar, but across the country. And when I go to the Heckerling conference next week with many other attorneys, this is going to be considered the most important document of all the documents, the financial power of attorney. So for many of you, the advanced medical directive is going to be hugely important, and it is. There's no question about that. But from an attorney's point of view in the estate plan, nothing is more important than your financial powers of attorney. I want you to dispel any notion that these financial powers of attorney are plain vanilla, that they're all the same, that one applies to one person just as much as it applies to another. Nothing could be further than the truth, and from the truth, I should say, and also that you have the opportunity to customize your individual financial powers of attorney. And as we're going to see here, I'm going to skip through these just in the interest of time. When we get to the advanced medical directive, we also are going to say, well, we want to see you customize that too. You don't have to, but remember, with regard to healthcare decisions, for some of you, this is going to be the only opportunity that you'll ever probably take to translate some of your, or articulate some of your healthcare decisions or your feelings about healthcare to your agent. So we like to see you customize this, but you don't have to. Advanced directives are very informal, so we can do a lot of customizing, and we encourage you and give you the opportunity to do that here at our firm. The MOLST form, the medical order for life-sustaining treatment, Maryland remains one of the only states that requires this. So if you don't have any education on this, I strongly recommend you speak to one of our attorneys or go visit the Attorney General's website here. Very exciting, I know, but go get yourself educated and learn about healthcare decision-making in Maryland. Talk to your doctor if you're older about MOLST and see how they feel about it. And for some of you, an aging life care manager who may be consulting with you or your loved one is going to have opinions about the MOLST form. All right, Jeff, if there's no questions, I'm going to keep moving forward to end on time. It's 10:40. We're going to shift gears now and talk about taxes. So we are living in an amazingly upward environment as far as taxes being exempt. So from the estate tax point of view, we are living in a world now where each person on the federal level has a 13,990,000. Why they didn't just make it 14 million, I have no idea. 13,990,000 for each person. And remember that if you are married, you have the opportunity to use the portability concept, which means on the death of one of you, the survivor of you can port or use the federal exemption of your deceased spouse. Now, the Maryland legislative structure says that it has portability as well. So we are very lucky, unlike DC that does not have portability. Maryland has portability of a deceased spouse's unused exemption amount. Now, if you are struggling with this particular slide, I don't blame you. If you are single, this will not apply to you unless you were previously married within a certain period of time. But if you are married, this slide will have more consequence to you for the idea that you can use your exemption and the exemption of your deceased spouse if you choose portability. So we want to talk about that if you have questions about it. If you are a married couple, you can exempt almost 28 million with no estate tax. Now this law, the American Tax Relief Act of 2010, is set to expire, many of you are aware of this, on January 1st, 2026, less than 12 months from now. But we have a new Congress, and who knows whether they are going to extend the tax laws beyond January 1st, 2026 to continue the tax cuts. Who knows what's going to happen? But right now we have unprecedented amounts, and the Maryland exemption amount is 5 million per person, meaning a married couple can exempt 10 million through the technique of portability. Now, in planning today, we can accomplish a lot of tax advantages and still accomplish marital control or remarriage protection and many of the issues that have to do with married individuals. Apologizing again to the people on this call who are not married, but if you are married or thinking about getting married, you should get yourself educated about protecting yourself. Maryland has new laws about spousal elections. This has nothing to do with taxes. This has to do with protecting spouses. And the laws are very, very pro protection. So much so that you have to protect yourself if you do not intend your surviving spouse to get everything. So prenuptial agreements and other things that have to do with marriage are part of the current tax environment, but also the current protection environment. Now, many people, switching gears now over to elder law very briefly, many people do not understand the difference between estate planning and elder care planning or elder law, and I don't blame them for being confused. I want you to think about estate planning as the disposition of assets, tax planning, all of these questions about should I leave assets in trust? Am I providing divorce protection for my children? How am I leaving assets for my surviving spouse? All of these things have to do with estate planning. Elder care planning crosses over into the world of disability, obviously, and we are concerned with issues like asset preservation for long-term care. In both, actually, we are concerned about flexibility, building in flexibility. And I just want to take less than a minute to say, in the world today, we are in a very happy place as far as the laws of Maryland about estate planning, in my opinion. If I had spoken to you or met you 20 years ago, I would not be able to say the same thing. Maryland law has become very much updated, very much flexible, and the theme in today's world really seems to be in estate planning, plan with flexibility. And the same thing is true with elder care, elder law. We want to plan with flexibility, and we'll talk more about that before we end. In elder law, back to this slide, we may be thinking about divesting our assets to our children so we can preserve our life savings and our life investments. Maybe we want to do a little bit of preserving our own assets for ourselves, but also gifting assets to our children. You could be a person who needs Medicaid. Medicaid pays for about 85% of long-term care, so elder care addresses this. Maybe you are a person who's a veteran, and you are an eligible veteran for certain pensions that have to do with the tax-free benefit called AID, AID, aid and attendance. So elder care is about planning for disability, housing, Social Security, special needs maybe, special needs planning for spouses, contracts for long-term care, facilities, continuing care retirement communities, Medicaid planning, veterans asset income planning. All of these things have to do with elder care. But as you can see in the next to last slide, or the second bullet point, I should say, we want to be able to do these things without giving up tax benefits, without giving up total control of the assets, and being able to basically hit several planning stones with one, planning goals, I should say, with one stone. All right, so we're going to keep moving. And as we start moving toward the latter part of the presentation, I do want to put this idea of asset protection into perspective. So asset protection is a huge subject, and asset protection is going to mean different things to different people. That's why I like to break it down into at least three categories. So let's look at lifetime asset protection first. What do I mean by this? Well, if you are married, and I apologize again to single people, you are entitled to have assets titled as tenants by the entireties, spouses. And there is a basic asset protection level afforded by this. It is not perfect, but it does provide a certain level of asset protection. And you can own assets other than just real estate as tenants by the entireties. And that's like brokerage accounts, and we should be aware of this. Life insurance is protected from the claims of creditors if your spouse or child is the beneficiary. Many people do not know that. Annuities are protected for the same reasons. Qualified plans and IRAs are protected from the claims of creditors. However, inherited IRAs, when you leave an IRA to a child or anyone else other than a spouse, that is not protected because that is called an inherited IRA. And the Supreme Court ruled many years ago that IRAs are not protected when they are left for children. For example, the Supreme Court argued that the children have no expectation of continuing to preserve assets or saving assets for retirement, that basically was an inheritance, and it was no different than any other inheritance. Therefore, it is not a subject to being protected from creditors. So we have to realize this, and we have to plan accordingly. Some of you will want to take advantage of asset protection in other states, such as domestic asset protection states, such as Delaware, Nevada, Alaska, South Dakota, Wyoming, and so forth. So just remember, lifetime asset protection is available. It is harder to get, but in some things like these things on this slide here, there is asset protection by just basically how things are titled or the kind of how the asset itself is owned. So just be aware of that. Now, we're going to go to a different kind of asset preservation now, and this is the Medicaid asset protection. So those of you on this webinar who are concerned about Medicaid and elder law kind of planning, these have to do with all the things I talked about earlier, but it also has to do with the Medicaid Asset Protection Trust. This is arguably one of the most powerful tools in all of estate planning today, which is a hybrid irrevocable trust. Elville & Associates does quite a bit of work and has quite a bit of knowledge and expertise in the area of these Medicaid trusts, and also Veterans Asset Protection Trust, which is a similar tool, but different for a different purpose for veteran benefits. And also that we use a lot of wills that are established, trusts, I should say, that are established under wills. And this is a strategy under the federal law to preserve assets where a spouse might be ill with a progressive illness, but one spouse is still healthy and living at home or another residence. And this is kind of the fundamentals that get discussed a lot in elder care. The crisis planning. Now we have people that have nursing home situations and terrible health situations, then we have to plan for a crisis. But if we can plan in a pre-crisis way and get ahead of the 5-year period, which was established in 2005 under the George W. Bush administration, we call this the 5-year look period. So there's a lot of strategy and a lot of planning that can go into this kind of issue, including, if you go to the next bullet point down, the rule of halves, or what is called the half loaf. So for those of you who do pre-crisis planning, we can possibly save 100% of the planned assets to be preserved through a proper 5-year look strategy. Or for those who do not get through the 5 years, it's possible to save somewhere between 50 and 100% possibly of the assets. But for those who never do any pre-crisis planning, but still have the sufficient flexibility in their planning, remember the financial powers of attorney, all of those things, there's a lot of flexibility that can be built in. And even in a crisis situation, it is possible to save upwards of 50%, even if no planning was done previously, to try to preserve assets it's possible to still preserve hopefully upwards to 50% and still be able to get Medicaid benefits under the current law. Life estate deeds are beyond the discussion today, but basically it's a simple strategy to be able to save assets for long-term care purposes. It is a one-dimensional strategy. It is not appropriate for everyone because it has to do with an irrevocable gift to others, but it's something that can be discussed and it can be used successfully. When we get outside of elder care and when we get outside of the lifetime kind of asset protection, then we get to planning at death. And planning at death, as funny as it sounds, is actually a pretty structured way to be able to protect assets. So you can protect assets for a surviving spouse in trust, or protect children or grandchildren or nieces and nephews from the claims of divorcing spouse or other creditors, or from their own actions. Or if that particular child or grandchild has disabilities or special needs, we can build a plan, and through the very, very nice laws that we have today, we can structure a plan where they have protection, there's control over their shares, and trustee selection. Jeff and I do a workshop on trustee selection that I strongly recommend that you watch if you have questions about trustees. Nothing could be more important, perhaps, in planning than structuring the right trustees and structuring flexibility, such as a trust protector. So remember that asset protection during life could mean that you implement a trust during life, not just at death, but in this particular slide, asset protection at death, that is a further trust that you provide under your will or under your trust, revocable trust, or under a separate trust, like a Medicaid trust. These trusts are going to provide asset protection depending on how you structure them, and you can protect beneficiaries depending on what your goal is. You can also, and I'll end on this as far as this slide, you can also make sure that Uncle Sam cannot tax the property again down at your children or grandchildren generational level. So remember, proper trust planning in some cases has to do with making sure, in many cases, that Uncle Sam can tax you at your generational level, and whether or not Uncle Sam gets any tax is going to be depending on how many assets you have and your planning. But when you leave those assets down to other beneficiaries in further trusts, if those are structured properly, Uncle Sam will not be able to tax those beneficiaries at their generational level, and the assets can continue to grow estate tax-free, not income tax-free, but estate tax-free. Now, as we start to really wrap up, the Secure Act came into law in 2020. It has been revised twice. And the Secure Act, unfortunately, affects most people. It affects most estate plans, not all. But it basically said that your children, your beneficiaries that are healthy, have to pay tax on the inherited IRAs that they receive within 10 years. And most of you have heard about this by now, but there are some exceptions, and we're going to talk about those exceptions real quick. And I'll go ahead and just give you those exceptions. So young people who are under 21 who receive an IRA from you, they are exempt under the Secure Act until they are 21. Then we have people who are less than 10 years younger than you. This could be a sibling of yours, or it could be an older sibling of yours. That person that is less than 10 years younger than you is exempt. Then we have spouses that are exempt under the Secure Act. And then we have chronically ill people, disabled people or special needs individuals, and their special needs trust, or what we would call supplemental needs trust. These people and those trusts are exempt if they are done right. So we want to make sure that you and your planning and your IRAs or 401ks or retirement plans in general are analyzed for purposes of the Secure Act, because you may not do anything differently with your planning, or you may decide to do something such as second to die life insurance or some other strategy, or Roth conversions or something to try to deal with the negative impacts of the Secure Act on your beneficiaries. And if you have beneficiaries that are exempt, we want to make sure that you're maximizing how you leave those inherited IRAs to those beneficiaries. As we start to wrap up on time, which I promised I would do, Remember that Elville and Associates has a client care program. We are very serious about this. Now, we do have fun in our client care program. We do have wine events and baseball events and theater events and things like this. And we would invite you to join our client care program and have fun, have fellowship, and also get educated. But the main purpose of our client care program is to provide a certain number of attorney hours per year to our members with other benefits. But also, really, the purpose is to encourage our members to update their planning and to educate their family members. That's really the purpose of the Client Care Program. And we are very grateful to the Client Care Academy in Boston for having helped us develop this program. And I'm grateful for Jeff, who is the coordinator of our CCP, we call it. So if you have questions about our Client Care Program, we are happy to invite you to one of our next upcoming meetings. And we encourage you to, again, keep your assets aligned, keep your documents updated, keep updated with the laws, and basically educate yourself and your family members, and at the same time, have fun. So as we wrap up on time, I encourage you to not just get educated, but to take action. We are here to help you. We are here to work hard with you to get things the way they should be and update over time so that your planning actually works. Collaborate with your financial advisory team and CPA. If you do not have a team like this, please let us know and we'll help you. We know and work with many very, very stellar financial advisors and CPAs who are committed to the same thing that we are here, which is education and client care. We want you to know that there's nothing to fear about this. And I want to just spend 30 seconds on this. Remember that when you come and you get more information or you meet with us, there's no charge for an estate planning consultation. But remember that it is an attorney-client relationship. Even if you do not become a client, you are here sharing, or by Zoom or however we do it, you are sharing information, and that is privileged information. There is nothing to fear, because if you do not become a client, we understand, but there's still this relationship. So we just encourage you to bring your questions, bring your documents, have further questions of all kinds. We are here to answer them and help you. We're mainly here to be in partnership with you to help you think through your goals. If you don't know what your goals are, we're here to help you have an epiphany through the process of education to determine what those goals are. And again, if you don't have a collaborative team, we recommend that. We are going to help you get a collaborative team if you don't have one, but work with the existing one that you do have and really collaborate with them. So whatever your goals are, we are here to help you. And I thank you for spending an hour of your time with us this morning. And Jeff, I'm going to turn it back over to you. I'm wishing everyone a blessed 2025.
Steve, thank you very much. Lots of great information to start the year off right. So we do have a few more questions, and we'll go ahead and run through those, and now be a perfect time to get any final questions that you have into Steve and me here. So Steve, first question here is, if a person has all beneficiary designations and or joint accounts and is diligent in maintaining these, can that be sufficient, or can a will be sufficient? Things like paper bonds are, in this person's word, a pain with trusts, it seems.
Yes, thank you for that. And I agree with you. If you have paper bonds, you know, they what we used to call the Department of Public Debt, but I guess it's Treasury Direct now. We have to send those bonds in. We have to get them retitled in the name of a trust. I agree with you that there's a little hurdle there to get everything titled in a trust. But your fundamental question, I think, is this: is it possible to leave everything by beneficiary designation? And of course, absolutely. If your beneficiary survives you, God willing, and you pass away first, and they have no issues in life, everything is very straightforward, and your goal was that it be very straightforward, then absolutely that will work. I think what happens in the life planning process, where people are living so long, you know, people living into their 90s or over 100, and all the things that we're seeing today, it's possible for people to become disabled or injured or brain injured on the highway, or whatever could happen in life. And that kind of planning is fine if it works. But if it doesn't work, it means that assets could pass to someone who has a disability. It could pass to someone who is being sued. It could pass to someone who is, you know, getting divorced. So I guess good planning has contingencies, right? If we use wills or trusts, whereas if we use the one-dimensional kind of planning that you're talking about, it can work and it could work perfectly. But kind of a precautionary kind of estate planning would be to build in lots of potential flexibility. So that's the only problem that, from an estate planning point of view, that we see with these kinds of things. The other issue is we don't generally want to use a joint account. Remember, when you title assets jointly with someone, two or three things can happen there. One, you are opening up the claims of the potential claims of creditors of the other joint owner, your child. You're opening up your assets to the potential claims of that person's creditors, something you generally would not want to do with any kind of joint ownership. So that's the first problem with that. The second problem is if it's anything other than cash, you are giving up basis. So what you are doing when you make a gift to someone, let's say through a joint account or some gift, and the gift rules, of course, are complex. We'd have to look at them. But in theory, you could end up being deemed to have given someone a gift of assets. And that means that when you pass away, there's no step up in basis that we normally would have gotten through a will or a trust. Or you could have gotten also the step up in basis through a transferable on death designation. So just watch joint ownership as a general rule.
Okay, thank you. Next question is, for the Maryland statutory power of attorney, it is not clear to me why using the special instructions is not sufficient.
Good question. Well, I think that for some people it would be. Let's talk about the Maryland statutory power of attorney. So we have the long form, we attorneys call it, and that's quite a broad form, right? It's got a lot of choices, it's got a lot of powers in there, and it's got the special instructions. Then we have the short form. The short form is what a lot of estate planners use. It's got special instructions. Generally, advanced estate planners in Maryland are going to use the short form with a layered general power of attorney, because the short form power of attorney, for example, has got some more enhanced powers in it, but it doesn't really cover the kind of estate planning powers that estate planning attorneys would counsel people about. So I don't know if I'm going to understand your question 100%, but if I understand what I think I do about it, the special instructions are not going to cover, if we were only using a statutory power of attorney, the special instructions would not allow you to cover all of your estate planning bases that, let's say, an estate planning attorney might want you to cover. Now, that's not to say you wouldn't be satisfied with it, or that the couple of things that you might want to put in the special instructions would be fine for you. But again, it's all about goals and it's all about counseling. And if your estate planning attorney is saying to you, well, listen, I understand your goals here, but have you thought about this and have you thought about this, and building in a lot of flexibility for the future, the statutory form might not be enough, and the statutory form special instructions might not be enough. But everything is different, every circumstance is different. And as I mentioned, no power of attorney should be the same, because no situation is the same. They are not all plain vanilla, especially when we start talking about using the special instructions and customizing them.
Okay, very well said, thank you. Regarding taxes, do you do the Form 706 and MET-1? If you do you engage outside CPAs or another firm to do these? And same question for the Form 709.
Well, thank you for that. Yes, so we do prepare Form 706 and MET-1 and Form 709. Some clients use their CPAs to do those forms, and lawyers typically will do those forms in estate planning. So yes, our firm does prepare those forms. That's a great question. Thank you.
And last question is the cost of the client care program. Is that a yearly cost, or is it embedded in the cost of establishing your estate planning documents?
Well, that's a wonderful question. I think right now, Jeff, I think we're charging $895 as our fee per year.
Correct. Yeah.
And Jeff can send out the particulars about the client care program. That includes 3 events, and then we have our regular client event, but it also has 2 discounted attorney hours as part of the planning process, meaning the legal work, whether it's estate planning or other planning, you get a credit of 2 hours of time, and other benefits. So it's that is basically what our current pricing is on that. And thank you for asking that question. Yes. And
Yeah.
Jeff, did I answer everything? There was another aspect of that, I think.
No, that's
That was it.
that's the correct answer. Yeah, I'll just say I'll as we wrap up here, I will make sure I send out the presentation that I did about our client care program back in beginning of December, and that's going to be a quarterly presentation going forward. It talks about all the benefits of the client care program, and certainly the value of it is more than the initial cost of it.
Oh,
So,
Jeff, I know what it was now, if you don't mind. I'm sorry to interrupt.
sure.
I think what I was going to say is it's not embedded in the cost of the estate plan. However, if a potential client or a client joins the client care program, when we are doing an initial estate plan, we do not charge for the funding and alignment of assets if a client becomes a member of the client care program. So
Right.
It's not embedded, but we do substitute a charge that we normally charge to fund the estate plan at a time of a revocable trust if you join the CCT. Sorry, Jeff.
Okay, no, very good. All right, so thanks to everybody for their great questions and for being here today. I, as always, send out a message with some hopefully good follow-up information for you, including the video from today that you can review, the slides, information about MOLST, links to other webinars that reference today's subjects a little bit more specifically, and some other things. So I'll go ahead and get that sent out within the next couple hours. And as we move forward with our webinar series, we have a pretty busy January. We're going to have on January 15th, we have Victoria Hathaway from the Bob Lucido team, one of our really wonderful partners here at Elville and Associates and in the community. She is very experienced and very knowledgeable. She's going to talk about pocket listings in real estate. What are they and how can they help or hurt when I'm selling my property? So it's always great to have Victoria as part of our webinar series. And then on January 22nd, we're partnering with NAMI Howard County, the National Alliance on Mental Illness, to discuss planning for a loved one with special needs, an overview of guardianship, supported decision-making, and special needs trusts. So they are a wonderful organization as well. And then to round out January, we're going to be talking about understanding estate and trust administration on January 29th. So look forward to seeing you again on our webinar series, and make this the year that you engage with your planning if you haven't done it for a while, or if you're just getting started. Again, Steve said, there's nothing to fear. Come in for a consultation and we'll show you the process and how to get taken care of. So have a great day. Thanks for being here, and we'll see you again soon on the Elville webinar series.